Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Torres v. Texas Department of Public Safety. In this case, the court considered this issue: did Congress properly abrogate state sovereign immunity for claims arising under the Federal Uniformed Services Employment and Reemployment Rights Act of 1994, USERRA? The case was decided on June 29, 2022. The court held that by ratifying the Constitution, the states agreed their sovereignty would yield to the national power to raise and support the armed forces. Congress may exercise this power to authorize private damages suits against non-consenting states, as in USERRA. Justice Breyer delivered the opinion of the court, in which Chief Justice Roberts and Justices Sotomayor, Kagan, and Kavanaugh joined. Justice Kagan filed a concurring opinion. Justice Thomas filed a dissenting opinion, in which Justices Alito, Gorsuch, and Barrett joined. The opinions are presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Breyer delivered the opinion of the court. The Constitution vests in Congress the power to raise and support armies and to provide and maintain a navy. Pursuant to that authority, Congress enacted a federal law that gives returning veterans the right to reclaim their prior jobs with state employers and authorizes suit if those employers refuse to accommodate them. This case asks whether states may invoke sovereign immunity as a legal defense to block such suits. In our view, they cannot. Upon entering the Union, the states implicitly agreed that their sovereignty would yield to federal policy to build and keep a national military. States thus gave up their immunity from congressionally authorized suits pursuant to the plan of the Convention, as part of the structure of the original Constitution itself. Congress has broad and sweeping power to raise and support armies. It has long exercised that power to encourage service in the armed forces in a variety of ways. Since before the United States' entry into World War II, Congress has sought, in particular, to smooth volunteers' re-entry into civilian life by recognizing veterans' right to return to civilian employment without adverse effect on career progress in the federal workforce and private employment. The Vietnam War prompted Congress to extend these protections to employment by states. Amidst political opposition to the war, some state and local jurisdictions had demonstrated a reluctance, and even an unwillingness, to re-employ returning service members. So Congress authorized private damages suits against states to ensure that veterans who had previously held jobs as school teachers, policemen, firemen, and other state, county, and city employees would not be denied their old jobs as reprisal for their service. The statute at issue, USERRA, embodies these protections today. Petitioner Leroy Torres enlisted in the Army Reserves in 1989. In 2007, he was called to active duty and deployed to Iraq. While serving, Torres was exposed to toxic burn pits, a method of garbage disposal that sets open fire to all manner of trash, human waste, and military equipment. Torres received an honorable discharge. But he returned home with constrictive bronchitis, a respiratory condition that narrowed his airways and made breathing difficult. These ailments, Torres alleges, changed his life and left him unable to work at his old job as a state trooper. Torres asked his former employer, respondent Texas Department of Public Safety, Texas, to accommodate his condition by re-employing him in a different role. Texas refused to do so. Torres sued Texas in state court. He argued that Texas had violated USERRA's mandate that state employers rehire returning service members, use reasonable efforts to accommodate any service-related disability, or find an equivalent position, or its nearest approximation, where such disability prevents the veteran from holding his prior position. Texas moved to dismiss the suit by invoking sovereign immunity. The trial court denied the motion. A divided intermediate appellate court reversed, stating this court's precedents established that Congress could not authorize private suits against non-consenting states pursuant to its Article I powers except under the bankruptcy clause, and citing Central Virginia Community College v. Katz. The Supreme Court of Texas denied discretionary review. After the decision below, this court decided Penn East. There, we recognize that the states had waived their sovereign immunity as to the exercise of the federal eminent domain power under the structure of the Constitution pursuant to the plan of the Convention. We then granted Torres' petition for certiorari to decide whether, in light of that intervening decision, USERRA's damages remedy against state employers is constitutional. Congress enacted USERRA as an exercise of its power to raise and support armies and to provide and maintain a navy. The question before us is whether the Constitution allows Congress to enforce these federal reemployment protections by authorizing private litigation against non-compliant state employers that do not wish to consent to suit. The Constitution forged a union, but it also protected the sovereign prerogatives of states within our government. Generally speaking, the states entered the federal system with their sovereignty, including their sovereign immunity, intact. Basic tenets of sovereign immunity teach that courts may not ordinarily hear a suit brought by any person against a non-consenting state. But states still remain subject to suit in certain circumstances. States may, of course, consent to suit. Congress may also enact laws abrogating their immunity under the 14th Amendment. And, as relevant here, states may be sued if they agreed their sovereignty would yield as part of the plan of the convention, that is, if the structure of the original Constitution itself reflects a waiver of state sovereign immunity. Actions do not offend state sovereignty if the states consented to them at the founding. Alexander Hamilton described 3 circumstances where the plan of the convention implied that the states waived their sovereign immunity: where the Constitution in express terms granted an exclusive authority to the Union, where it granted in one instance an authority to the Union and in another prohibited the states from exercising the like authority, and where it granted an authority to the Union, to which a similar authority in the states would be absolutely and totally contradictory and repugnant. Consistent with these principles, this court has found structural waiver as to suits between states, in South Dakota v. North Carolina, and suits by the United States against a state, in United States v. Texas. The states, we said, must have recognized that these waivers of immunity from suit were a necessary feature of the formation of a more perfect union and thus inherent in the constitutional plan. The alternative to consenting to litigation between sovereigns, after all, could be civil war. A century later, in Central Virginia Community College v. Katz, the court recognized another structural waiver. We held that states could not assert sovereign immunity to block suits by private parties pursuant to federal bankruptcy laws. There, too, we based our holding on the constitutional structure. We noted the text's insistence on uniform laws on the subject of bankruptcies, the framers' concerns about states passing patchwork legislation and refusing to discharge the debts of non-citizens, as had happened under the Articles of Confederation, and the history of habeas laws related to bankruptcy. All that evidence led us to conclude that, by ratifying the Constitution, the states had agreed that their sovereignty would yield to ensure the effectiveness of national bankruptcy policy. For several years, both before and after Katz, the court declined to acknowledge additional waivers of sovereign immunity under Congress Article 1 powers or to find Article 1 authority to abrogate immunity. 2 terms ago, we even described Katz's analysis as good for one clause only, suggesting we would not find further waivers under Article 1. Last term, in Penn East Pipeline Company v. New Jersey, we considered whether Congress could, pursuant to its eminent domain power, authorize private parties to sue states to enforce federally approved condemnations necessary to build interstate pipelines. We held that when the states entered the federal system, they renounced their right to the highest dominion in their lands, meaning they agreed their eminent domain power would yield to that of the federal government. Congress could therefore authorize private actions against states. Penn East defined the test for structural waiver as whether the federal power at issue is complete in itself, and the states consented to the exercise of that power, in its entirety, in the plan of the convention. Where that is so, the states implicitly agreed that their sovereignty would yield to that of the federal government so far as is necessary to the enjoyment of the powers conferred upon it by the Constitution. By committing not to thwart or frustrate federal policy, the states accepted upon ratification that their consent, including to suit, could never be a condition precedent to Congress' chosen exercise of its authority. The states simply have no immunity left to waive or abrogate. Congress' power to build and maintain the armed forces fits Penn East's test. The Constitution's text, its history, and this court's precedents show that when the states entered the federal system, they renounced their right to interfere with national policy in this area. For one thing, the Constitution's text, across several articles, strongly suggests a complete delegation of authority to the federal government to provide for the common defense. Unlike most of the powers given to the national government, the Constitution spells out the war powers not in a single, simple phrase, but in many broad, interrelated provisions. The preamble makes the common defense one of the document's central projects. Article 1 gives Congress authority to provide for that common defense in 6 numbered paragraphs, to declare war, raise and support armies, provide and maintain a navy, make rules for the armed forces, provide for calling forth the militia, and provide for their organizing, arming, and disciplining. Article 2 makes the President the Commander-in-Chief of the Army and Navy of the United States, and of the militia of the several states. And the federal government is charged with protecting each state against invasion. The Constitution also divests the states of like power. States may not engage in war, unless actually invaded, enter into any treaty, or keep troops, or ships of war in time of peace. States retain a role in the appointment of the officers to and the training of the militia, but that delegation is strictly cabined. States must do so according to the discipline prescribed by Congress. These substantial limitations on state authority, together with the assignment of sweeping power to the federal government, provide strong evidence that the structure of the Constitution prevents states from frustrating national objectives in this field. History teaches the same lesson. When the framers met in Philadelphia in the summer of 1787, they sought to create a cohesive national sovereign in response to the failings of the Articles of Confederation. The founders recognized, first and foremost, that the Confederation produced no security against foreign invasion, Congress not being permitted to prevent a war nor to support it by their own authority, because Congress lacked the power to marshal and maintain a fighting force fit for defense. The want of power in Congress to raise an army had left the national government dependent upon the states to supply military forces via a system of quotas and requisition that had nearly cost the nation victory in the Revolutionary War. George Washington warned from the battlefield that, unless Congress is vested with powers by the several states to raise an army, our cause is lost. In short, the experience of the whole country, during the Revolutionary War, established, to the satisfaction of every statesman, the utter inadequacy and impropriety of this system of requisition. The need to fix that failing by establishing a strong national power to raise and maintain a military was one of the recognized necessities for calling the Constitutional Convention. The Constitution, by design, worked an entire change in the first principles of the system. The framers gave Congress direct power over the formation, direction or support of the national forces. So general and indefinite were these powers vis-à-vis the states that objections were made against them as subversive of the state governments, which retained no control on Congress under the new arrangement. Some state conventions pitched proposals to limit the reach of Congress' war powers, but those amendments died away. The states ultimately ratified the Constitution knowing that their sovereignty would give way to national military policy. Consistent with that structural understanding, Congress has, since the founding era, directed raising and maintaining the national military, including at the expense of state sovereignty. For instance, early Congresses established military bonuses to reward service, even requiring Virginia to give land to some Revolutionary War officers. Could Virginia have refused to go along? We do not think so. As President Lincoln reflected while the Civil War raged, the federal power to raise and maintain a military is given fully, completely, unconditionally. It is not a power to raise armies of state authorities' consent, it is a power to raise and support armies given to Congress by the Constitution, without an if. An unbroken line of precedent supports the same conclusion. Congress may legislate at the expense of traditional state sovereignty to raise and support the armed forces. During the Civil War, this court rejected a state's attempt to retrieve, through habeas corpus, a deserted soldier held in the custody of a recruiting officer of the United States. The national government's power to raise and support armies cannot be questioned by any state authority, we said. In Stewart v. Kahn, the court approved a federal statute that, among other provisions, told state statutes of limitations in state courts for suits against soldiers while they were in service of the Union. The court described Congress authority as carrying with it inherently the power to remedy state efforts to frustrate national aims. Objections sounding in ordinary federalism principles were untenable. In the early 20th century, the court again rejected state sovereignty objections in this area, this time to the draft. We wrote that Congress' authority to raise armies could not be qualified or restricted by the states because the Constitution manifestly intended to give all such power to the federal government and leave none to the states. Modern examples illustrate the same structural point. In United States v. Oregon, this court rejected a state's 10th Amendment challenge to a federal law providing that, when certain veterans die without heirs, their property distributes to veterans' facilities rather than as cheating to the state. Even though estate and property law are areas normally left to the states, the court explained that those background assumptions are displaced when it comes to Congress' constitutional powers to raise armies and navies. When, years later, the court adopted a broader view of state sovereignty under the 10th Amendment, the court was careful to clarify that nothing we say in this opinion addresses the scope of Congress' authority under its war power. Nor is the federal government's power limited to the context of an actual war, as we held more recently in Perpick v. Department of Defense. After the governors of California and Maine refused to allow their state's National Guard members to be sent on training missions in Honduras, Congress eliminated the long-standing requirement that the military obtain consent from the relevant governor before transferring National Guard members to active military service. The court rejected the notion that so holding nullified an important state power, instead recognizing the supremacy of federal power in the area of military affairs. The lesson we draw from these cases is that the power to wage war is the power to wage war successfully. The framers had emerged from a long struggle which had taught them the weakness of a mere confederation, so they established a union which could fight with the strength of one people under one government entrusted with the common defense. Under our constitutional order, states may not place any limitations inconsistent with Congress' power because every resource of the people must be at command. In short, the states agreed to divest themselves of the traditional diplomatic and military tools that sovereigns possess to sacrifice their sovereignty for the common defense. It follows that Congress' power to build and maintain a national military is complete in itself. Text, history, and precedent show the states agreed that their sovereignty would yield, so far as is necessary to national policy to raise and maintain the military. And because states committed themselves not to thwart the exercise of this federal power, the consent of a state, including to suit, can never be a condition precedent to Congress' enjoyment of it. We consequently hold that, as part of the plan of the Convention, the states waived their immunity under Congress Article 1 power to raise and support armies and provide and maintain a navy. Neither Texas nor the dissent persuades us otherwise. Texas asserts that Congress cannot abrogate state sovereign immunity through the exercise of Article 1 powers. But, as explained, congressional abrogation is not the only means of subjecting states to suit. States can also be sued if they have consented to suit in the plan of the Convention. We recognize that waiver today, as we have before in Penn East and Katz. The dissent, but not Texas, adds that Congress needed to speak more clearly to subject Texas to suit because USERRA could be read to incorporate state law, perhaps including Texas immunity laws. But USERRA's text is clear: Congress sought to authorize suits against state employers. The very provision to which the dissent cites is entitled Enforcement of Rights with respect to a state or private employer. USERRA elsewhere expressly supersedes any state law that reduces, limits, or eliminates in any manner any right or benefit provided by this chapter, including the establishment of additional prerequisites to the exercise of any such right or the receipt of any such benefit. Congress' clarification that suits proceed in a state court of competent jurisdiction in accordance with the laws of the state merely addresses the fact that USERRA suits must be brought in state, rather than federal, court. Under Supremacy Clause principles, Texas courts may not enforce contrary state laws to block these suits. Texas and the dissent go on to suggest that the fact that an area of law is under the exclusive control of the federal government is not alone sufficient to do away with sovereign immunity. We agree. In Seminole Tribe, we held that Congress could not rely on its Article 1 commerce powers to abrogate state sovereign immunity simply because that power was exclusive. But later, in Penn East, we found that the federal eminent domain power was complete in itself, and held that was enough to find a waiver of sovereign immunity in the constitutional structure. That federal regulation of commerce, at issue in Seminole Tribe, involves goods that, before they travel between states or outside a tribe, are subject to regulation by a sovereign other than the federal government, a state or tribe. That feature of commerce arguably makes the federal regulatory power less than complete. The dissent takes issue with this complete in itself inquiry. But its quarrel lies with Penn East, which used the formulation we rely upon today. In any event, the text, history, and precedent we have described indicate that an assertion of state sovereignty to frustrate federal prerogatives to raise and maintain military forces would be strongly contradictory and repugnant to the constitutional order. Neither Seminole Tribe nor the cases that followed it, such as Florida Prepaid, considered federal powers that give rise to these same structural inferences. None of those powers, e.g., Indian commerce, interstate commerce, or intellectual property, is expressly denied to the states, or operates for the benefit of the entire nation, or proves comparably essential to the survival of the Union, itself a foundational purpose for drafting the Constitution. These factors, taken together, lead us to conclude that the results in Penn East and Katz, not dicta in Seminole Tribe, control this case. The dissent makes two further points. First, it quotes Alden v. Maine for the proposition that the powers delegated to Congress under Article 1 of the United States Constitution do not include the power to subject non-consenting states to private suits for damages in state courts. But the dissent would give this sentence more weight than it can bear. The quoted passage appears in the introduction to the court's opinion, and it refers summarily to Article 1's general delegations, i.e., Congress' broad authority under the Supremacy Clause and the Necessary and Proper Clause. Alden did not, in this sentence or elsewhere, suggest that there were no exceptions under which Congress could authorize private suits against states. In fact, Alden said the opposite. The court expressly embraced the postulate that states shall be immune from suits, without their consent, save where there has been a surrender of this immunity in the plan of the Convention. So, Alden made clear, in exercising its Article 1 powers, Congress may subject the states to private suits in their own courts, if there is compelling evidence that the states were required to surrender this power to Congress pursuant to the constitutional design. As we have discussed, Penn, East and Katz recognize such exceptions as to the federal eminent domain power and the bankruptcy clause. And they establish the test for what constitutes compelling evidence of structural waiver. The dissent next implies that Penn, East and Katz create special rules regarding waivers of sovereign immunity in federal courts that do not apply in state courts. But those opinions' reasoning about our constitutional structure is not so limited, as Alden reflects. Alden held that Article 1 did not, in general, give Congress the power to set aside states' immunity from suit in their own courts, despite the 11th Amendment's silence on the subject of state courts. The amendment's text refers only to federal courts, the judicial power of the United States. Like our other state sovereign immunity cases, Alden understood the 11th Amendment to stand not so much for what it says, but for the presupposition of our constitutional structure which it confirms. It follows that a waiver pursuant to the plan of the Convention, as we found in Penn, East and Katz, displaces the background principles of state sovereign immunity wherever those suits proceed. Neither Alden nor any other case holds to the contrary. The dissent would leave us with a constitutional structure that allows Congress to authorize private suits against states only by abrogation under the 14th Amendment, by legislation under the bankruptcy clause, but only for suits in federal courts, or by delegation of the federal eminent domain power, but, again, only in federal courts. The logic of that constitutional design is anything but clear. Texas tries another tack to distinguish Penn, East and Katz, focusing on a technical aspect of those cases. Texas says that both eminent domain and bankruptcy involved in rem proceedings, which are inextricably intertwined with the exercise of those federal powers. The proceeding before us, Texas adds, is not in rem or so intertwined. We agree, of course, that Penn, East discuss the close connection between the exercise of eminent domain and condemnation actions. But we read Penn, East as resting on a broader point: the federal government's eminent domain power is complete, such that no state may frustrate its exercise by claiming immunity to forestall the transfer of property. And that conclusion applies equally to Congress' powers to raise and maintain the military. Texas further argues that Congress cannot subject it to suit under USERRA because there is no founding-era history of similar litigation against states. But Penn, East did not require any such history, as the dissent acknowledges. Again, in Penn, East, we considered the inferences that flow from our constitutional structure and asked whether states may, consistent with that structure, claim immunity to frustrate federal objectives. And again, answering that question here, we find that the states waived their immunity under Article 1, Section 8, Clauses 12 and 13. Texas' contrary view would permit states to thwart national military readiness. We need not stray from the statute at hand to see the danger of this approach. If a state, or even 25 states, decided to protest a war by refusing to employ returning service members, Congress, on Texas telling, would be powerless to authorize private reinstatement suits against those states. The potentially debilitating effect on national security would not matter. We think it does matter for a simple reason. Text, history, and precedent show that the states, in coming together to form a union, agreed to sacrifice their sovereign immunity for the good of the common defense. We consequently reverse the judgment of the Texas Court of Appeals and remand the case for further proceedings not inconsistent with this opinion. It is so ordered. Justice Kagan, concurring. In my view, our sovereign immunity decisions have not followed a straight line. 2 years ago, I described Katz's plan of the convention analysis as good for one clause only, i.e., Article 1's bankruptcy clause. I thought then that our precedents had shut the door on further Article 1 exceptions to state sovereign immunity. But Penn, East proved me wrong. The question there was whether the states had consented in the plan of the convention to the federal government's exercise of Article 1's eminent domain power, including through private parties' suits. Relying on our prior decisions, I concluded that the states had not so consented. But the court ruled otherwise. Using a new test, it held that the eminent domain power was complete in itself, meaning that the states had consented to the federal exercise of that power in its entirety. The question today, given Penn, East, is whether the same is true of the war powers. Were those powers also complete in themselves, so that the states likewise consented to congressionally authorized private litigation? The answer is yes, as the court holds. Much more than eminent domain, war powers lie at the heart of the convention's plan. The overriding goal of the convention was to create a cohesive national sovereign in response to the failings of the Articles of Confederation. And among those failings, none was more important than the one of power in Congress to raise an army and the dependence upon the states to provide armed forces. For that reason, the war powers, more than any other power, and surely more than eminent domain, were complete in themselves. They were given by the states, entirely and exclusively, to the federal government. Penn East's analysis thus compels today's result. In setting out the complete in itself test, the court there answered the question here: at the convention, the states waived their sovereign immunity to any suit Congress authorized under the war powers. Justice Thomas, with whom Justice Alito, Justice Gorsuch, and Justice Barrett join, dissenting. More than 2 decades ago, this court found it difficult to conceive that the Constitution would have been adopted if it had been understood to strip the states of immunity from suit in their own courts and cede to the federal government a power to subject non-consenting states to private suits in these fora. Accordingly, we held, without qualification, that the powers delegated to Congress under Article 1 of the United States Constitution do not include the power to subject non-consenting states to private suits for damages in state courts. No longer. Today, by adopting contrived interpretations of Alden and the recent decision in Penn East Pipeline Company v. New Jersey, the court holds that at least 2, and perhaps more, Article 1 war powers do, in fact, include the power to subject non-consenting states to private suits for damages in state courts, and that Congress has exercised that power by enacting the Uniformed Services Employment and Reemployment Rights Act of 1994, USERRA. Alden should have squarely foreclosed that holding. As the court there already explained, constitutional text, history, and precedent all show that when the states ratified the Constitution, they did not implicitly consent to private damages actions filed in their own courts, whether authorized by Congress war powers or any other Article 1 power. Because the court today holds otherwise, I respectfully dissent. After declaring independence, the former colonies considered themselves fully sovereign nations. And, when the states ratified the Constitution, they entered the Union with their sovereignty intact, retaining a substantial portion of the nation's primary sovereignty, together with the dignity and essential attributes inhering in that status. An integral component of the state's sovereignty was their immunity from private suits absent consent. That doctrine was universal in the states when the Constitution was drafted and ratified, because the generation that designed and adopted our federal system considered immunity from private suits central to sovereign dignity. In fact, sovereign immunity was so important that the Constitution never would have been ratified if the states and their courts were to be stripped of their sovereign authority except as expressly provided by the Constitution itself. Although states generally retained their immunity from suit, in ratifying the Constitution, they did surrender a portion of their inherent immunity. As Alexander Hamilton explained in The Federalist, sovereign immunity was part of the general sense and the general practice of mankind, and the Constitution therefore left it with the states unless they had surrendered some portion of this immunity in the plan of the Convention. During the nation's first 200 years, this court recognized only 2 instances in which the states had surrendered their sovereign immunity in the constitutional plan, both of which involved suits prosecuted by other sovereigns. The states had agreed to be sued by other states in this court. When it came to private litigation, however, this court long maintained that the framers thought it an impermissible affront to a state's dignity to be required to answer the complaints of private parties in federal courts, and that the convention did not disturb states' immunity from private suits. Nevertheless, in the last 2 decades, the court has recognized 2 surrenders of sovereign immunity in cases implicating private parties. First, in Central Virginia Community College v. Katz, this court held that states waived immunity against the federal discharge of debts when they ratified the bankruptcy clause. And, in Penn East, it held that states waived immunity against condemnation proceedings brought by private parties to whom the federal government has delegated its eminent domain power. Taken together, Katz and Penn East centered on whether or not the plan of the Convention, i.e., the Constitution itself, required states to surrender their sovereign immunity. These cases contrast with those that involve congressional abrogation of state sovereign immunity. Abrogation rests on some statement Congress has made on the subject of state sovereign immunity. Specifically, we have held that Congress must enact unequivocal statutory language abrogating states' immunity. Seminole Tribe of Florida v. Florida. That said, the line between plan of the Convention waiver and congressional abrogation is a murky one. Both inquiries ask the same basic question: whether Congress has authorized suit against a non-consenting state pursuant to a valid exercise of constitutional authority. And both inquiries center on history, practice, precedent, and the structure of the Constitution, to determine whether the Constitution either grants authority to Congress to abrogate immunity or strip states of their immunity on its own. The parties agree that this case involves only plan of the Convention waiver. Thus, the question presented is whether, in ratifying the Constitution, the states surrendered their immunity in their own courts against private damages actions authorized by Congress war powers. In answering that question, the court discounts 2 important points. First, it creates a constitutional problem by adopting a questionable interpretation of USERRA that assumes Congress intended to legislate with indifference to state law immunity. Second, the court cannot escape the fact that Alden already answered the question presented and held that the states did not surrender their state court immunity when ratifying Article 1 of the Constitution. When it was originally enacted, USERRA authorized covered employees to sue states in federal district court. In 1996, this court decided Seminole Tribe, holding that Congress could not abrogate state sovereign immunity in federal courts using its Article 1 powers. In response to Seminole Tribe, Congress amended USERRA in 1998, and the statute now provides, in the case of an action against a state, as an employer, by a person, the action may be brought in a state court of competent jurisdiction in accordance with the laws of the state. USERRA's requirement that employee damages actions be in accordance with the laws of the state would seem to include a state's laws that render it immune from suit in the state's own courts, as well as any laws that expressly waive such immunity. In other words, there is nothing in the text of USERRA necessarily implying that Congress intended to require non-consenting states to defend themselves in their own courts. The court, however, breezes past USERRA's language to conclude that the statute authorizes private litigation against non-compliant state employers that do not wish to consent to suit. To be clear, I am not disputing whether USERRA speaks clearly enough to express a congressional intent to abrogate the state's sovereign immunity in their own courts. Plan of the Convention waiver asks whether the states surrendered that immunity when the Constitution was ratified and thus agreed, not to assert that immunity in particular contexts. But even if the Constitution itself partially strips state sovereign immunity, it would still fall to Congress to decide whether, and on what terms, to render states amenable to suit, or to permit states to assert immunity. The court should not casually consider the constitutionality of USERRA's supposed subjection of non-consenting states to damages actions in state court when it is not clear the statute does any such thing. By doing so, the court gives short shrift to the well-established principle governing the prudent exercise of this court's jurisdiction that normally the court will not decide a constitutional question if there is some other ground upon which to dispose of the case. Having interpreted USERRA to render non-consenting states amenable to suit, the court goes on to distinguish Alden v. Maine without any plausible basis for doing so. In truth, Alden directly controls this case. In Alden, a group of private plaintiffs sued the state of Maine in state court, invoking a private cause of action created by the Fair Labor Standards Act, FLSA. The question presented was whether Congress has the power, under Article 1, to subject non-consenting states to private suits in their own courts. In a detailed opinion, the court in Alden held, without qualification, that the states had not consented in the plan of the convention to any congressionally created private damages actions in state court. To begin, Alden framed its inquiry around plan of the convention waiver, not congressional abrogation. In exercising its Article 1 powers, Congress may subject the states to private suits in their own courts only if there is compelling evidence that the states were required to surrender this power to Congress pursuant to the constitutional design, i.e., in the plan of the convention. In determining whether such evidence existed, Alden began with the text of the Constitution. It recognized that Article 1, Section 8, grants Congress broad powers to enact legislation in several enumerated areas of national concern, including, of course, the war powers. But neither the breadth of those powers nor their connection to areas of national concern suffice to show that states ratified the Constitution with the understanding that they had surrendered to Congress any power to authorize private damages actions against them in their own courts. Alden spoke emphatically and categorically when explaining why the states had effected no such surrender. We found it telling that no one, not even the Constitution's most ardent opponents, suggested the document might strip the states of their immunity from suit in their own courts. That was likely because the sovereign's right to assert immunity from suit in its own courts was a principle so well established that no one conceived it would be altered by the new Constitution. We explained how the founding generation's concern that Article 3 might be used to circumvent state court immunity counseled against inferring that the Constitution stripped the states of immunity in their own courts and allowed Congress to subject them to suit there. Rather, in light of the historical record, we found it difficult to conceive that the Constitution would have been adopted if it had been understood to strip the states of immunity from suit in their own courts and cede to the federal government a power to subject non-consenting states to private suits in these fora. Importantly, the scope of Alden's holding was broad. We hold that the powers delegated to Congress under Article 1 of the United States Constitution do not include the power to subject non-consenting states to private suits for damages in state courts. That holding plainly applied to all Article 1 powers. Thus, we did not engage in a clause-by-clause parsing of Article 1's various powers, nor did we even mention which Article 1 power authorized the FLSA. It did not matter because the states would not have surrendered to Congress any of the immunity they enjoyed in their own courts. Finally, concluding its analysis, Alden contrasted the state's amenability to suit by the United States on behalf of the employees with a suit by the employees themselves, holding that history, precedent, and the structure of the Constitution make clear that, under the plan of the Convention, the states have consented to suits of the first kind but not of the second. The question that Alden answered plainly embraces the one that the court answers today. And there is no serious dispute that Alden's explicit holding is irreconcilable with the court's holding here. Until today, Alden meant what it said. Both Katz and Penn East considered plan of the Convention waivers applicable to federal, not state, court. Nothing in those decisions, therefore, undermined Alden's categorical holding. It is only the court's holding today that does so. I would adhere to Alden and reaffirm that the states did not surrender the immunity applicable in their own courts when they delegated the enumerated powers, including the war powers, to Congress in Article 1. And, because Torres has not invoked a waiver of immunity under state law, I would affirm the judgment of the Texas Court of Appeals. Even if Alden's holding were not alone dispositive, thus requiring us to consider our plan of the Convention precedents applicable to private actions in federal court, I would still conclude that the states have not waived their immunity to private damages actions authorized by the war powers. Our settled test for plan of the Convention waiver is a stringent one. We cannot infer a waiver of sovereign immunity unless there is compelling evidence that the founders thought such a surrender inherent in the constitutional compact. Compelling evidence of this sort includes evidence of the original understanding of the Constitution, early congressional practice, the structure of the Constitution itself, and the theory and reasoning of our earlier cases. Applying this test, it is clear that the states did not implicitly agree to surrender their state court immunity against congressional exercises of the war powers. Torres claims, and the court agrees, that the original understanding of the Constitution's text implies that the states agreed to surrender their immunity against private actions authorized by Congress war powers, which include 8 powers enumerated in Article 1, Section 8, along with the necessary and proper clause. In support of that argument, Torres and the court point out that the war powers delegated to Congress are sweeping, and that Article 1, Section 10, expressly and completely divests states of various war-related powers. This argument falters on at least 2 fronts. First, Seminole Tribe long ago explained that the breadth and exclusivity of a federal power does not authorize Congress to subject non-consenting states to private damages actions. Seminole Tribe involved a federal cause of action created pursuant to Congress authority under the Indian Commerce Clause, which this court has said grants Congress plenary and exclusive powers to legislate in respect to Indian tribes. Although Seminole Tribe recognized that states had been divested of virtually all authority over Indian commerce and Indian tribes, the court nonetheless held that state sovereign immunity is not so ephemeral as to dissipate when the subject of the suit is an area that is under the exclusive control of the federal government. That the Constitution vests in Congress complete lawmaking authority over a particular area, we explained, does not implicitly authorize Congress to abrogate immunity with respect to that power. Nor is the answer different when the exclusive federal exercise of a particular power is reinforced by an explicit divestment of state authority under Article 1, Section 10. Our precedents teach that whenever a power is exercised exclusively by Congress, the subject is as completely taken from the state legislatures, as if they had been expressly forbidden to act on it. Whether or not a prohibition on state power also appears in Article 1, Section 10, is irrelevant when deciding whether the Constitution has granted Congress power to subject non-consenting states to private suits. Second, even if express textual divestment of state power were relevant, Torres and the court incorrectly conclude that the specific divestments listed in Article 1, Section 10, provide strong evidence supporting a complete delegation of authority to the federal government to provide for the common defense. States obviously have no authority to take certain actions specified in Article 1, Section 10. They cannot, for example, keep troops or ships of war in time of peace, unless actually invaded, or in such imminent danger as will not admit of delay without the consent of Congress. But to say that Congress much more general authority to raise and support armies, acts to completely derogate all state authority related to the subject is inaccurate. States have significant residual police powers that overlap with Congress power over the military. For example, we have sustained state legislation related to the enlistment of men in the U.S. Army and Navy against the charge that all power of legislation regarding the subject matter is conferred upon Congress and withheld from the states. In doing so, we rejected the idea that a state has no interest or concern in the United States or its armies or power of protecting them from public enemies, and eschewed any cold and technical reasoning that insists on a separation of the sovereignties in the army-raising context. Similarly, we have held that there is no clause of the Constitution which purports, unaided by congressional enactment, to prohibit states from exercising their police powers in ways that arguably burden Congress' power to raise and support armies. nor have we implied from the relationship of the two governments established by the Constitution any such prohibition. State regulations inevitably impose some burdens on the national government, but those are the normal incidents of the operation within the same territory of a dual system of government, and they may persist save as Congress may act to remove them. Therefore, even though the Army and Navy clauses grant Congress exclusive authority over raising and supporting armies and navies, that exclusivity is no different from that which attends any other Article I power. To nonetheless find plan of the Convention waiver, as Torres proposes and the Court accepts, is to hold that a congressional power to preempt state law alone demonstrates a state's surrender of sovereign immunity. That line of reasoning, apart from being foreclosed by Seminole Tribe, proves too much. The upshot is that the states would have consented in the plan of the Convention to surrender their immunity against the exercise of any Article I power. Because such a result is a dramatic departure from our precedents, and the power granted to Congress under the Army and Navy clauses does not displace state regulation any more readily or completely than other Article I powers, these arguments from constitutional text provide no sound basis for authorizing private actions against non-consenting states. Constitutional history and practice do Torres and the Court know better. To begin, we must view the historical evidence in light of the presumption that no anomalous and unheard-of proceedings or suits were intended to be raised up by the Constitution. Applying that presumption, the Court in the past has attributed great significance to the absence of analogous suits at the time of the founding or for many years thereafter. Moreover, the presumption is arguably at its strongest here, for private damages actions were precisely the type of proceedings from which the framers would have thought the states possessed immunity. The framers would have thought it an impermissible affront to a state's dignity to require it to defend itself in an adversarial proceeding against a private party. To overcome that presumption, Torres and the Court invoke some historical sources that generally discuss the scope and importance of Congress' war-related powers. But virtually none of them addresses directly the central question here, whether the states understood that they had surrendered their sovereign immunity from suit in their own courts when delegating those powers to Congress. Instead, the founding-era history is largely silent on this question, and that silence is most instructive in confirming that no one conceived that state sovereign immunity would be altered by the new Constitution's distribution of war powers. The founders' silence is best explained by the simple fact that no one suggested the document might strip the states of their immunity under the war powers. More specifically, Torres, but not the Court, points to the 1783 Treaty of Paris. He maintains that private actions would not have been anomalous to the founders because they expected British creditors to sue states under the treaty in order to collect on their debts. But it is not likely that the founders did, in fact, expect foreign creditor suits against states. It is more likely that they expected creditors to sue their individual debtors and rely on the treaty to defeat any state law defenses. And when the 11th Amendment was adopted to restore the original constitutional design after Chisholm v. Georgia, Congress refused to make an exception for cases arising under treaties made under the authority of the United States. Congress' refusal to modify the text of the 11th Amendment to create an exception to sovereign immunity for cases arising under treaties suggests that the state's immunity from private party litigation extended even to treaty-based claims. Early congressional practice accords with the framers' assumption that Congress could not use any Article I power to subject the states to private damages actions in their own courts. In fact, we already have discovered no instance in which early Congresses purported to authorize suits against non-consenting states in state courts. Contrasted against the numerous statutes authorizing other federal suits in state courts, it appears early Congresses did not believe they had the power to authorize private suits against the states in their own courts. Constitutional structure also cuts decisively against inferring a surrender of state sovereign immunity in this context. First and most fundamentally, all private suits against non-consenting states present the indignity of subjecting a state to the coercive process of judicial tribunals at the instance of private parties. USERRA's cause of action is uniquely offensive to the state's dignity because it purports to press a state's own courts into federal service to coerce the other branches of the state, thereby turning the state against itself and commandeering the entire political machinery of the state against its will and at the behest of individuals. That kind of plenary federal control of state governmental processes denigrates the separate sovereignty of the states. Second, congressional authorization of private damages actions threatens the financial integrity of the states. It can create staggering burdens and give Congress a power and a leverage over the states that is not contemplated by our constitutional design. Third, representative government itself is jeopardized when deliberation by the political process established by the citizens of the state is replaced with judicial decree mandated by the federal government and invoked by the private citizen. Political accountability, essential to our liberty and republican form of government, breaks down when the federal government asserts authority over a state's most fundamental political processes. Notwithstanding these countervailing structural concerns, both Torres and the court think that constitutional structure supports finding plan of the convention waiver because confirming states' sovereign immunity in their own courts would supposedly threaten the federal government's power to wage war successfully and jeopardize the nation's safety. But this argument conflates the preservation of state sovereign immunity with a license to interfere with federal warmaking. As we already cautioned in Alden, the constitutional privilege of a state to assert its sovereign immunity in its own courts does not confer upon the state a concomitant right to disregard the Constitution or valid federal law. For example, the court notes that early Congresses established military bonuses to reward service, even requiring Virginia to give land to some Revolutionary War officers. It asks, incredulously, could Virginia have refused to go along? But that question is a non sequitur. No one disputes the supremacy of federal power in the area of military affairs. Instead, all agree that the United States could lawfully sue Virginia in federal court to secure an injunction requiring it to comply with federal law. In fact, USERRA already authorizes suits by the United States to enforce USERRA's requirements. And even if private suits were necessary to enforce the federal scheme, individuals could still sue in equity to enjoin state officials from violating federal law, or if Congress authorizes it, pursue damages actions against such state officials in their individual capacities. Ultimately, if the court reaffirmed Texas sovereign immunity, established rules provide ample means to correct ongoing violations of law and to vindicate the interests which animate the Supremacy Clause. Finally, our precedents do not support finding a surrender of state sovereign immunity here. As explained above, Alden is the most on-point precedent, and, in fact, our only recent precedent discussing states' immunity from suit in their own courts. It therefore disposes of this case. Neither Katz nor Penn East supports a different result. Katz found plan of the convention waiver based on the singular nature of bankruptcy jurisdiction and the bankruptcy clause's unique history. As the court later explained, Katz viewed bankruptcy as on a different plane, governed by principles all its own, and nothing in its analysis invites the kind of general, clause-by-clause re-examination of Article 1 that the court endorses today. For its part, Penn East emphasized several factors unique to the eminent domain context. First, Penn East discussed the federal government's long history of exercising the power of eminent domain, including its delegation of that power to private parties to take property within state boundaries. Here, there is a long history showing that the federal government exercised its war powers, but there is no comparable history of the federal government using those powers to impose financial liabilities on states enforceable by private parties. Nor is there any evidence demonstrating that any kind of judicial proceedings, let alone private damages actions, are inextricably intertwined with the war powers in the way that judicial condemnation actions are intertwined with eminent domain. Second, Penn East emphasized that the Constitution vests the federal government with full and complete power to execute and carry out its purposes, including the power of eminent domain, and that history shows that the government may exercise that sovereign power through private delegatees. Here, there is no argument that employees granted a cause of action under USERRA are delegatees of the war powers in any meaningful sense. Third, Penn East reasoned that recognizing New Jersey's immunity claim would require federal delegatees to take state property, thereby forcing states to file inverse condemnation actions for just compensation. The court did not think the kind of arrangement would vindicate the principles underlying state sovereign immunity, including the principle of affording states the respect owed them as joint sovereigns. Here, by contrast, there is no sense in which confirming Texas immunity would similarly undermine the principles underlying that immunity. In the end, the history, practice, precedent, and the structure of the Constitution all demonstrate that states did not surrender their sovereign immunity in their own courts when Congress legislates pursuant to one of its war powers. The court nevertheless holds that states surrendered their sovereign immunity for any congressional causes of action passed pursuant to Article 1's Army and Navy clauses. To reach that conclusion, the court adopts a test that even Torres did not press. Relying exclusively on Penn East, the court maintains that plan of the convention waiver distills to a single question: whether the federal power at issue is complete in itself. If so, then the states have surrendered their sovereign immunity against any exercises of that power. After framing the inquiry this way, the court concludes that because Congress' power to build and maintain the armed forces is complete in itself, states necessarily relinquish their sovereign immunity against private damages actions authorized by that power. In my view, the court is asking the wrong question. It unjustifiably asserts that the entire plan of the convention inquiry rests on whether a power is complete in itself. Further, its complete in itself standard misreads Penn East, which suggested only that because the federal eminent domain power was complete in itself and, by its nature, inextricably intertwined with judicial condemnation proceedings, states surrendered any sovereign immunity that would otherwise render the eminent domain power incomplete. By saddling completeness with more analytical weight than it can bear, the court has devised a method that has the certainty and objectivity of a Rorschach test. Beyond its inconsistency with Penn East, this contrivance also threatens to rework or erase the court's prevailing sovereign immunity jurisprudence. The sentence in Penn East upon which the court fabricates its test for plan of the convention waiver reads as follows: the federal eminent domain power is complete in itself, and the states consented to the exercise of that power, in its entirety, in the plan of the convention. The court today claims that this sentence in Penn East reduced our decades-old state sovereign immunity jurisprudence to merely asking whether a federal power is complete in itself. That cannot be correct. The court in Penn East borrowed the complete in itself idea from Cole, which had approved the federal government's condemnation of private land to build a post office in Cincinnati, Ohio. Although the federal government had relied on Ohio's eminent domain power, rather than its own, Cole made clear that the federal government's authority to condemn land did not depend upon state law. In doing so, Cole stated that if the United States have the eminent domain power, it must be complete in itself. It can neither be enlarged nor diminished by a state. Nor can any state prescribe the manner in which it must be exercised. The consent of a state can never be a condition precedent to its enjoyment. Before Penn East, the phrase complete in itself never appeared in our modern state sovereign immunity precedents. Penn East itself invoked the concept for one purpose: to reject the contention that one could separate the eminent domain power from the power to condemn, i.e., to disaggregate those inextricably intertwined powers, when determining whether the history of federal eminent domain supported finding a waiver of state sovereign immunity. According to Penn East, to deprive the federal government of a power to condemn property in judicial proceedings brought by private delegatees would be tantamount to depriving the government of part of the eminent domain power itself, contrary to Cole's characterization of that power as complete in itself. The court today errs by attributing to Cole an outsized role in Penn East's sovereign immunity analysis. The court in Penn East never stated that completeness in itself represented the governing test for plan of the convention waiver. Likewise, Penn East made no effort to explain how the complete in itself inquiry would work beyond the context of eminent domain. And because Penn East did not invoke Cole to break new doctrinal ground, the court made no attempt to reconcile the complete in itself inquiry with this court's long-standing sovereign immunity precedents, e.g., Alden, Seminole Tribe, Federal Maritime Common, Hans, etc. Again, if Penn East had made completeness in itself the applicable test, surely the court would have discussed the concept more thoroughly. The court compounds its overreading of Penn East's complete in itself language by unjustifiably dismissing Penn East's inextricably intertwined rationale as a mere technical aspect of the decision. Penn East is best read to stand for the proposition that, because every federal power must be complete in itself, the states surrendered their sovereign immunity with respect to any federal power that is inextricably intertwined with judicial proceedings, like eminent domain. Otherwise, sovereign immunity would excuse the states from the judicial proceeding and the federal power would be incomplete. Yet, now, the court abandons the only limiting principle in Penn East's test. That is mistaken. To begin with, disaggregating the complete in itself standard from Penn East's inextricably intertwined justification renders meaningless the idea of completeness in the context of state sovereign immunity. Consider the court's opinion here, which says that any federal power complete in itself must be accompanied with a surrender of state sovereign immunity. The court does not define what it means for a federal power to be complete in itself, except that the states consented to the exercise of that power, in its entirety, in the plan of the convention. But that self-referential definition begs the question. If the court tied the completeness of a federal power to an inherent connection with judicial proceedings, it could give the term independent meaning and make sense of Penn East's actual analysis. Worse still, today's decision removes the one important guardrail on the completeness inquiry that Penn East described. Absent that limit, the court's indefinite test will provide future courts cover to further erode the state's sovereign immunity. To the extent that the court's new complete in itself standard has any definable contours, it is inconsistent with our modern sovereign immunity doctrine and, in particular, Seminole Tribe. As I noted above, the court does not define what it means for a federal power to be complete in itself under Penn East and Cole. All we are told is that eminent domain and the powers to raise and support armies and navies are powers complete in themselves. The court's completeness standard is indeterminate in large part because the court fails to recognize that the concept of a federal power being complete in itself long predates Cole and means something quite different from what the court says it does. In fact, The phrase's provenance in our jurisprudence dates back to no less seminal a decision than Chief Justice Marshall's opinion in Gibbons v. Ogden. There, the court stated that Congress' power to regulate commerce with foreign nations, and among the several states, like all others vested in Congress, is complete in itself, may be exercised to its utmost extent, and acknowledges no limitations, other than are prescribed in the Constitution. Gibbons' discussion is revealing. First, unlike the court's decision today, which attempts to cabin congressional powers that are complete in themselves to only a few, Gibbons is explicit that it considered every power vested in Congress to be complete in itself. That understanding would explain why Cole said that if the United States have the power, it must be complete in itself. Second, unlike the court today, Gibbons defines what it means for a power to be complete in itself. The power may be exercised to its utmost extent with no limitations beyond those in Constitution itself. In other words, the power is plenary as to those subjects to which it applies. Gibbons' understanding of a congressional power being complete in itself was repeated by this court time and time again for nearly 2 centuries. Almost always, the court used the term to refer to Congress' authority to regulate interstate and foreign commerce. And, over time, the court confirmed that because Congress' power over interstate commerce is plenary and complete in itself, it follows that no form of state activity can constitutionally thwart the regulatory power granted by the Commerce Clause to Congress. This language echoes Cole's holding that the federal eminent domain power can neither be enlarged nor diminished by a state. Ignoring this long history about the very completeness standard that it purports to apply, the court grasps for some basis to explain how its decision is consistent with this court's understanding of Congress' commerce power in Seminole Tribe. It asserts that Congress' power under the Army and Navy clauses is somehow complete in itself while its power under the Commerce Clause is less than complete because federal regulation of commerce, at issue in Seminole Tribe, involves goods that, before they travel between states or outside a tribe, are subject to regulation by a sovereign other than the federal government, a state or tribe. But the court's proposed distinction makes no sense. For one, it conflicts with the court's long-standing characterization of Congress' commerce power as plenary. As long as the goods mentioned by the court are in fact part of interstate commerce, then Congress has authority to regulate their travel at all times. For another, it does nothing to distinguish Congress' commerce power from its power to raise and maintain a military. Following the court's logic, one could just as easily say that Congress' power under the Army and Navy clauses is less than complete because federal regulation of soldiers involves men and women who, before they join the military, are subject to regulation by a sovereign other than the federal government. Despite the court's efforts, its completeness analysis simply fails to distinguish the Army and Navy clauses from other Article I powers delegated to Congress in the plan of the Convention. Most troubling, however, is the clear parallel between the court's analysis today and the discredited approach to sovereign immunity that we rejected in Seminole Tribe. For example, in Pardon v. Terminal Railroad Company of Alaska Docks Department, the court relied on Gibbons' complete in itself language to hold that the states surrendered a portion of their sovereignty when they granted Congress the power to regulate commerce. Pardon reasoned, not unlike the court today, that the sovereign power of the states is necessarily diminished to the extent of the grants of power to the federal government in the Constitution, and that granting Congress plenary power to regulate commerce amounts to a surrender of immunity. Similarly, in Pennsylvania v. Union Gas Company, the plurality emphasized how it would be difficult to overstate the breadth and depth of the commerce power, and how the Commerce Clause with one hand gives power to Congress while, with the other, it takes power away from the states. In light of this dual grant of federal authority and divestment of state authority, the plurality thought Congress' commerce power would be incomplete without the authority to render states liable in damages. To complete that congressional power, the plurality reasoned that to the extent that the states gave Congress the authority to regulate commerce, they also relinquished their immunity where Congress found it necessary, in exercising this authority, to render them liable. We repudiated Pardon and overruled Union Gas in Seminole Tribe. Therefore, if Seminole Tribe was right, then the court's decision today is wrong. Hopefully, the court will someday purge the newly fashioned completeness standard from our jurisprudence. Congress has ample means to ensure compliance with valid federal laws, but it must respect the sovereignty of the states. If the court's reading of USERRA is correct, and I am unsure it is, then Congress has not accorded states the esteem due to them as joint participants in a federal system. To nonetheless deem USERRA constitutional, the court brushes aside a 23-year-old, path-breaking precedent, while elevating a single phrase, made in passing in a 1-year-old, highly circumscribed precedent. It then uses that phrase to fashion a test for plan of the Convention waiver that mimics earlier attempts by this court to deny states the dignity owed to them in our system of dual federalism. Our sovereign states deserved better. I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. If you would like to support my efforts to make Supreme Court opinions available to the public, please go to the podcast's website. It's at anchor.fm/SCOTUS-opinions/support. Again, the website address is anchor.fm/SCOTUS-opinions/support. There you can also see other episodes and send a message to me, the podcast's creator. Thank you.